Please go ahead.
All right. Thank you.
I would like to reserve 5 minutes. My name is Nevin Weiner. I represent the appellants in this case, and the pending appellants are McHale and Russell Pillifant, even though the caption includes a reference to the Southwest Florida Police Benevolent Association Inc. They have, that entity was dropped as a party. This is an appeal from an order of dismissal with prejudice that was entered by the trial court on November 15th, 2013, of an amended complaint that had been filed on September 11th, 2012. And maybe that's an ominous date to file any pleading, which if I had thought of that, I probably would have waited an extra day just to avoid that significance. The amended complaint states a cause of action for declaratory judgment and for injunctive relief, which changes but replicates the same causes of action that were filed in the original complaint back in November 1, 2011. The amended complaint, however, asserts a class action basis for proceeding forward, which was not asserted in the original complaint. The original complaint was recommended for dismissal with leave to amend by the magistrate, which was approved by the trial judge. The magistrate's recommendation was in June 21st, 2012, and the order adopting the magistrate's recommendation was July 10th, 2012. And the concerns that the magistrate had at that time was whether or not the PBA was a proper party and had standing, concerns about the class action status that were less than clear, and that there were no contracts attached to the complaint, and it was unclear, according to the magistrate, as to what was being asked to be construed. We would submit that the question about what was being asked to be construed was clear, but we didn't need to appeal that decision because we were granted leave to amend. And what the record will show is that Exhibit A, Exhibit B, and Exhibit C to the amended complaint, which were identical exhibits to the original complaint, are the instruments that were sought to be construed. Exhibit A is a resolution by the City of Sarasota, number 93R674, that was passed on September 20th, 1993. Exhibit B is a memorandum pertaining to the issue that was covered in that resolution, and that's dated September 7th, 1993. And Exhibit C is an agenda request dated 9/20/93.
The essence, really, of this case, as I see it, of course, is the obvious issue that the court said, we don't have jurisdiction here, this is an issue for PERC, we shouldn't be here. And one of the points has been raised in that regard, and that you were dismissed with prejudice because I guess in the court's mind, there was no way you're going to fix that problem. You need to seek your administrative remedies or at least exhaust them before you come to court. But the issue that's been raised is the preservation issue. Your opportunity to amend was not adequately preserved because you didn't seek leave to amend. Help me understand that issue a little bit.
Well, yes, the city does take the position that because we didn't ask for a rehearing or I guess instantaneously seek leave to amend, we're precluded from doing so. I would submit that that's not the right standard to apply here because that effectively would bar any review by this court of error by the lower court in not meeting the standards that we contend are applicable to motions to dismiss or motions to dismiss with prejudice. What I think that might do is say that we are not at this juncture allowed to seek any amendment to the complaint beyond the 2 counts that were included in the amended complaint. So that even though, as discussed before the trial court and alluded to by the city and myself in the conversations at the hearing, that there could have been a potential claim for breach of contract, since we did not seek that amendment before the trial court, did not seek to amend to state a count for breach of contract. I think it is a correct statement of the law that we are precluded from asking this court to allow us to amend the complaint. But this court, in reviewing whether or not a dismissal with prejudice is appropriate, does have a right to review whether or not the trial court correctly followed the law in dismissing the case with prejudice where it is obvious that an alternate cause of action could be stated. So though it had not been requested and therefore is not granted, this court can say, wait a minute, dismissal, it was obvious that one could be stated and that certainly leave to amend could be applied for and so forth, or the court should have just simply on its own declined to dismiss with prejudice and allowed leave to amend.
Can you explain to us in a concise and simple way why the claims that were asserted are not within the exclusive jurisdiction of PERC? And in your answer, please discuss separately the cases that relates to the active employee and the retired employee.
All right. I think there are two reasons why the matter was not within the jurisdiction of Chapter 447 or PERC. First and foremost is PERC declined jurisdiction, and that's clear from the record. The city, after the lawsuit was filed, attempted to divest the trial court of jurisdiction by belatedly filing an appeal to PERC, and that was denied by PERC. It was an untimely appeal by the city, and PERC simply denied it. So there is no alternate form or exhaustion of remedies available to any party in this case.
If there was some kind of failure to bargain or unfair labor practice or something like that, what prevented the employees from bringing it before PERC?
Well, the issue was, the reason why it couldn't be done was because the right that was bestowed occurred back in 1993, not in 2000. It wasn't the breach of the collective bargaining agreement, which there's never been a breach of the collective bargaining agreement. These rights that were afforded to the hires and the retirees of the Sarasota Police Department were not the part or product of a collective bargaining agreement. As a matter of fact, and as it's alluded to in the complaint, the amended complaint, the city was the one that did not want to make those benefits subject to collective bargaining. And because they did not want to do that, they induced the PBA, and the instruments that we've attached as the exhibits to the amended complaint show that the promise was that any pre-October 1, 1993 hire in the SBD, in the Sarasota Police Department, who was active or who fulfilled 10 years tenure and then retired, would be given paid lifetime medical dental benefits. It's only the post-October 1, 1993 hires that the city said that policy was going to change, and that those post-1993 hires would have to contribute and pay for the medical dental benefits that were to be conferred.
Well, didn't they stop paying in 2011?
That's the first time the city did that, from 1993 all the way through.
So why can't they complain to PERC about that in 2011?
Because it was never part of the collective bargaining agreement in the first place. And that was because the city did not want it to be part of a collective bargaining agreement. And so our position would be is that perhaps it could have been addressed then, perhaps so, but the circuit court has concurrent jurisdiction over these kind of issues. And it's important to understand that the rights that were being breached were contracts that were separate from and not part of a collective bargaining agreement. And so what the PBA did, I think, I was the attorney for it, but what the PBA started was litigation in circuit court to have the circuit court address these issues.
All right, well, do the retirees stand on a different footing from the active employees when it comes to PERC?
Well, absolutely, because retirees don't have the option of engaging in collective bargaining at all or seeking relief from PERC for rights that were violated for their rights, which are, of course, these rights are not part of a collective bargaining agreement. They do not have standing even to seek PERC review of this. And it's significant that the motion that the city filed to dismiss the amended complaint did not seek dismissal of the claims on the part of the retirees. The pre-October 1, 1993.
Let me ask you this question. Let's suppose, speaking hypothetically, that we decide to affirm the trial court's order. Are the retirees just out of luck, or do they have any other recourse?
I don't know of any other recourse that they would have, with the possible exception of, at this point, still being within the statute of limitations to bring a breach of contract action in the circuit court. They would not have any other forum that they could seek review from. PERC would not be available to them. If this court affirmed the dismissal with prejudice, I believe the only option would be to try to file an alternate suit alleging a breach of contract action directly, which goes back to my former point that this action itself, the amended complaint, could have been re-amended, and everybody acknowledges that. As a matter of fact, the city itself.
So have they done that? Have they filed a breach of contract action?
I'm sorry?
Have the retirees filed a breach of contract action?
No, Judge, although that is something that I've discussed with the PBA. I've been mulling that over because I'm not sure when this court might reach its decision in this case. If this court were to overturn the trial court, then probably we would seek an amendment in this action. But since there's a statute of limitations issue, I am considering actually, and we'll have to decide within the next few days before November, whether or not to actually file a contract, a separate breach of contract action. So those possibilities exist. I'm trying to be as efficient as I can. I have no idea when this court's going to make its ruling and let me know what my options are, but I believe lawfully that both the actives and the retirees who are pre-October 1, 1993 hires still have available to it the filing of a breach of contract action without seeking declaratory judgment or injunctive relief. I don't, however, hold to the view of the court that a cause of action for declaratory judgment or injunctive relief was not stated. I believe it was, and properly so, and that declaratory judgment is an available forum or means by which the court can review whether or not rights are.
Well, what's the argument for why a declaratory judgment was not available? Is it that the memos and interoffice stuff doesn't rise to the level of some enforceable contract that the court can interpret? I mean, is that what the argument is?
Well, that really wasn't clearly presented in the hearing below. That is what the city has maintained on appeal. It's very evident on appeal that's the city's position. We do not agree with that necessarily because contracts can arise when you're seeking a declaratory judgment about written instruments. The court ought to construe those.
I'm just trying to find out how we got here. I mean, what's the basis for the ruling?
Your Honor, I'm puzzled partly because I'm not sure what the judge ruled. He adapted the arguments without really explaining what the arguments were. That's one of the issues we've raised on the appeal, that the judge did not engage in adequate independent analysis. And that's one ground that we're seeking reversal just for itself. I'm not completely certain myself, and I don't mean to speak for the court. I can only speculate what the trial judge believed. I think from the order, it's safe to say that the trial judge agreed with the city's arguments, but I'm not sure precisely why the judge chose to do that, particularly, among other things, when the city was arguing about standing issues which were resolved when the PBA was dropped as a party. The city's motion wasn't even directed to the retirees. I mean, in all candor, I was caught a little bit off guard and with some surprise that the court didn't.
Well, I think they argued that the retirees didn't have a cause of action for declaratory judgment or injunctive relief.
I don't interpret their motion as going to the retiree issue. I think they were going to the active issues because they kept saying that that could be the product of collective bargaining. They kept saying that this is the alternate avenue that employees who are active employees can pursue.
Well, I thought they made it reasonably clear that in moving to dismiss for lack of jurisdiction, they were just talking about the active employees, not the retirees.
Well,
so if the entire action was going to be dismissed, there had to be some other basis for dismissing it as to the retirees.
Well, I don't know what that basis is, Your Honor, because my understanding of the motion and the arguments made before the court was that the argument by the city was directed only to the hires having alternate remedies, and therefore it should be dismissed for failure to state a cause of action, because we should pursue those either in negotiations or the city itself acknowledged it couldn't have it be reviewed by PERC. But it seems as if, to me, everything got blended, at least in the court order to court understanding of things, and the court didn't distinguish suitably that the argument the city was raising wasn't even directed to the retirees, but it nonetheless dismiss the entire complaint as to retirees as well as active employees. So I'm not sure, I don't know why, Judge. But I think it's clear when you look at the motion itself and the transcript of the hearings, the city wasn't arguing that the retirees had some other forum that they could go to or could participate in collective bargaining as a way of trying to resolve these issues. The city never made that argument.
You are at 15.
Excuse me?
You are at 15.
I am, okay. Thank you.
It's your time. You can keep going. Just want to let you know.
All right. Now, unless, Judge Wallace, if I should answer the question more thoroughly. Okay, thank you.
Good morning, Your Honor. I don't need that. That's a little loud. My name is Sarah Warren, and I'm an assistant city...
You might want to put that microphone right back
I do
there.
need it. Okay. My name is Sarah Warren, and I'm an assistant city attorney with the City of Sarasota, and I'm here with my co-counsel, Karen Morinelli. If it please the court, we would like to share this oral argument. I would like to present on the declaratory relief and injunctive relief claims, and Ms. Morinelli would like to present the collective bargaining issues.
Okay.
I'd like to start just by kind of briefly talking about the standard of review because the appellant misstated that in its brief. The court the appeals court should give great deference to the trial court and only overturn it if there's clear error. And this is because it's a different standard that's is usually used in a case involving a dismissal for failure to state a cause of action. And it's because the court has discretion to determine whether there is a need or a necessity for a declaration of rights. And the burden is on the plaintiff to show that there are doubts that need to be resolved. And in this case, the trial court properly exercised its discretion to dismiss the declaratory relief claim. And I hope I can explain it, our position, and it's the same position that we made to the court below, so you can understand maybe why the court ruled the way it did. We have kind of three primary arguments as to why the declaratory relief claim should have been dismissed. And the first is that there must be a bona fide dispute that's capable of being resolved by a written instrument. And in this case, we argue that the resolution that's attached to the complaint along with these related documents would not resolve the problem, would not resolve the predominant determinative claims of the plaintiffs that they have a claim for verbal promises. And their primary object appears to be to try these disputed questions of fact as to whether there were verbal promises made to these employees going back several decades.
Well, this isn't just about verbal promises, is it? I mean, they've got all these memoranda and everything that were flying back and forth about the policies and everything. What?
Well, if you look at the resolution and the memorandum, first of all, we would argue that they're very clear and unambiguous, and that alone can mean it's not appropriate for declaratory relief. But if you look at it, there's nothing in there that says that these pre-1993 hires are to get free lifetime medical benefits. And instead what it says is that they're only entitled to such plan as the city decides to offer. And it says that it actually cites to Florida Statute Section 1112-0801, which says that the retiree may be required to pay. So our argument is that, if anything, it negates this idea.
Well, I thought the idea on a declaratory judgment was not that you were necessarily entitled to win on your theory when you filed your complaint, but rather you would obtain a declaration from the court about your rights, which means you could either win on your position or you could lose, but you were asking the court to interpret it and clear it up so that everybody would know where they stood.
That's true, Your Honor, but declaratory relief is only available when the predominant claim rests upon construction of a document. So here the predominant claims are that these plaintiffs were verbal promises were made to them by the city. That is their predominant claim. That's the object. That's what they want the court to discuss, and they want to bring in that factual evidence. Now, factual evidence can come in a declaratory relief suit, but only when it's needed to construe the document. And here the document is clear and plain, and you don't need any factual evidence to construe it. Not only that, but the fact that it says that they may be required to pay, and that that they're only going to get the benefit, the plan that the city offers, that actually suggests the opposite to what they're asking for. So it really facially negates their claim.
Well, let me ask you this. Let's suppose that, speaking hypothetically again, we decide to affirm the lower court. Did the retirees have any other remedies, or are they just out of luck?
Well, that's a little bit tough to answer, because if the active employees go back and collectively bargain this issue, I suppose there's a possibility that something might change for them as well, that there might be some decision made that would include them. But I think that I agree that they wouldn't be able to themselves collectively bargain, and that they might have other remedies in court, such as a breach of contract action. And in fact, and this is in the record, there is another complaint. It's not pending at the moment, but it's going to be refiled pursuant to an agreement. But basically, there are other attorneys who are attempting to represent these folks as well. And we have had cases filed in federal court, 2 federal cases already. So I think, yes, I think that they might have other remedies in court. I think that the other thing that's important to remember is that while they were employed, they had the opportunity to collectively bargain this issue as well. So if they were relying on mere expectations, if they really had no contract right, they could have negotiated that while they were employed. Let me talk a little bit about our third major point, which is that we don't believe that the plaintiff's entitled to another amendment. And as you were discussing earlier, and as he seems to acknowledge, he didn't properly preserve by seeking leave to amend below. He was given the right to amend once, and he didn't adequately correct the complaint pursuant to the court's order, because, and he referenced this, the court did say, I'm confused. What are you asking the court to construe? It looks like you're asking the court to conclude that these verbal promises created a contract, but you haven't attached any written documents that support that. And he acknowledged that he didn't change the documents. He didn't find any additional documents. He continued to just attach these 1993 documents, which dealt primarily with, almost exclusively with, what happens to folks hired after 1993, not people hired before 93. I'd like to emphasize, too, that he did have many opportunities to ask the court for the right to amend during hearings. We had 2 lengthy hearings, one in February and one in November, on the motion to dismiss. And during the February hearing, the court actually asked him, well, why don't you file a breach of contract suit? Because in the course of his discussion, he'd been talking a lot about how the city had breached its agreements with these plaintiffs. And the court said, well, why don't you file a breach of contract suit? And he said, well, we did. Or well, we could. That could be a count, but what we're asking for instead is a declaratory judgment. And he went on to say, you know, we're asking the court to conclude that there was essentially a contract. So it appears to us that he's seeking an advisory opinion from the court before he files a breach of contract action, and that's an inappropriate use of the Declaratory Judgment Act. We think that, I mean, it appears from the record, and if you look at page 136 of the record, you'll see this discussion, that the plaintiffs made a conscious decision not to amend their complaint, to state a breach of contract claim, even when the court opened the door to that, and even when the city vociferously argued that declaratory relief was inappropriate. I'd like to just point real quickly, too, to the amended complaint, so that you can see that the predominant and the determinative claim is for breach of verbal promises. In at least 9 paragraphs, the plaintiffs point to and state that they have doubt as to their rights as a result of verbal representations. And in their actual count for declaratory relief, they don't say they're in doubt about their rights under the attached resolution and documents. They say they're in doubt about these verbal promises. So there's very little focus in the amended complaint on the language in these documents. They don't allege that it contains any promises of free lifetime benefits. They don't point to any ambiguities or possible ambiguities in these documents. They don't seek an interpretation of any specific language, and they don't point to any particular language that supports their claims. So while they allege that this resolution memo memorialize or reflect these verbal promises, when you look at the resolution and memo, it doesn't recall or reference any of these promises, any such promises. And again, going back to Section 1, which states that retirees, these pre-93 retirees, would continue to receive such plan as is offered by the city. And then in that third whereas clause, it talks about Florida Statute 112-0801, costs may be paid by the employer or the retired employee. So both of these statements really negate what they're claiming, which is that they were told they were going to receive free lifetime benefits and promised that for life.
Was I to tell you when you got to 10?
Okay, I'll wrap it up.
Was I? Then we're there.
That would be great, thank you. And again, declaratory relief is only available when the predominant claim rests upon construction of a written document. And we've cited to half a dozen or more cases in our brief: Kellner, Garner, Abruzzo, Johnson, Seifert, all of which stand for this rule of law, and that you can determine a question of fact if you need it to construe that document. But if your claim is primarily one of factual dispute, then declaratory relief is not the appropriate vehicle for you to use. You mentioned earlier, was there a discussion about whether a resolution could create contract rights? And that is sort of part of our argument as well, which is that a resolution is like a unilateral policy statement by a legislative body, and at any particular moment in time. And it's inherent in legislation that a future legislative body has the right to revise or repeal any previously adopted legislation. The courts are pretty clear on this, that legislation doesn't create contract rights for individuals unless it's pretty much spelled out in the legislation itself. So in summary, the undisputed purpose of the 93 resolution was to stop city subsidies for those hired after 93. The language is clear and unambiguous. It didn't promise that the existing practice of providing free benefits for these pre-93 hires would remain throughout their lifetimes. And a declaratory decree would serve no useful purpose because it wouldn't clarify and settle the legal relations at issue. The plaintiffs are seeking a determination that they have a cause of action for verbal promises, and that claim can't be resolved through construction of the resolution and related documents. The plaintiffs failed to preserve their right to amend the complaint, and they shouldn't be allowed to bring that forward now. As far as injunctive relief, just real quickly, in the first complaint, we argued to the magistrate that they had failed to adequately allege the 4 elements, and that they had not provided any factual support for those. And the court agreed with us, and then in the amended complaint, we hoped they would fix that, but it really wasn't corrected. And it's not enough to just parrot 4 elements. The courts, the Charlotte County v. Grant medical case from the 2nd DCA talks about needing clear, definite allegations of unequivocal facts to support each element. And if you fail to correct that based on a court order, that's grounds for dismissal. The City of Sarasota requests that the court affirm the court order below, dismissing the counts for declaratory and injunctive relief. Thank you.
Karen Morinelli with the firm of Ogletree Deacons on behalf of the city. In the few minutes that we have left, I'm going to address the city's position that the trial court also correctly dismissed the instant matter based on lack of subject matter jurisdiction, based on the exclusivity of PERC to decide these issues. There are 4 brief issues.
Can I ask you questions, though? Because I have questions on that subject, and maybe you can tailor this around my
In fact, if you want to ask me questions, go right ahead.
You've raised, there are 3 issues that I'm trying to get my hand around. One is the ripeness issue. One is why PERC dismissed when you all sought to take it to PERC, and this exhaustion of remedies argument that you make. As I understand that when you took it to PERC, they dismissed because they said the 6-month time period had run between the time the issue had occurred and there was a 6 months filing period. Then you argue this ripeness that no one's ripe yet. So on the one hand, too much time has passed. On the other hand, not enough time has passed, or at least one of these people have not put themselves in a position to do that. So explain that issue to me, because it sounds like what you're saying is, in the future, some of these members of the class will be eligible for PERC consideration. And at that point, that should be exhausted before you resort to circuit court on these issues.
Okay.
Have I
kind
I
of
made a
framed
mess
it.
of your nice argument, but go ahead.
No, that's fine. Actually, that cuts right to the chase. As far as PERC is concerned, and the reason why our unfair labor practice charge was denied is because we filed in 2013 with the express purpose of doing two things. One, to advise the court that really there were other avenues in 2011, well within the statute of limitations period, that the appellants could have filed a charge either with PERC, gone to try to negotiate with us through what is called impact bargaining, sat down at the bargaining table, or followed the collective bargaining process of a grievance and arbitration. We come late in 2013 after the amended complaint is filed, and what PERC says is you're outside of the 6 months of the initial complaint. So really it was more we were trying to get the union to come to the table to bargain with us by saying, hey look, if you didn't recognize previously that you had these rights under the collective bargaining agreement, here we are. Additionally, in 2011, which is in the record, the union did come to the city and said, we want to reserve the right to impact bargain retiree medical. The city said yes. The city can do no more than to say yes and be willing. It was the union who did not follow through on that. Instead, they waited till 10 months after the action of making the individuals pay for the benefits, and then they filed suit. So was their method purposeful to wait outside of the 6-month time frame and deliberately come to court because the court might treat them better than PERC might treat them? Because remember, if they had brought this to the city's attention and collectively bargained it, they would have had to have a give and a take. They might have put 3 or 4 things on the table, and the city might have said, well, we'll agree with these things, but not the others. So coming to court really circumvented PERC's jurisdiction in that matter. So that is the reason why our ULP was too late to be filed, but certainly they had the opportunity. As to the ripeness issue, the reason we even brought the ripeness issue up was during the first hearing on the amended complaint for the motion to dismiss in February of 2013, the trial court judge asked during our colloquy, well, aren't you really saying that the active employees, nothing's happened to them yet, it's too soon for them, they have no injury that's not ripe? What we did in the interim 9 months till we had the second half of the argument, and which would have been time for the appellants to amend their complaint because the judge gave us all suggestions during that first hearing, we did some research and we found a case that we thought was particularly on point. It's the Auerbach case, which is noted in our brief. And in that case, which is strikingly similar sets of facts, we had retired teachers who upon retirement they were going to get a benefit, and that benefit would be, in their case, a stipend. In our case, it is to continue or to get free medical premiums for individual employees, not for family, not for employee plus one, but for employees selecting the category of employee only in benefits. The Auerbach court said, well, wait a minute, there were 14 teachers who were part of the class. It was also an age discrimination claim, but as to this issue, the court said, wait a minute, 6 of you aren't retired. So this is not a retiree health benefit, or in their case, a stipend, so it's not ripe as to you just yet. The nexus between those two things, Your Honor, is that active employees today can negotiate for what happens to them in retirement. So right now, Sergeant McHale, for example, has the opportunity to say, wait a minute, all this stuff has been flying around for the past couple of years. I want to make sure when I retire and I elect single coverage, that's taken care of in the collective bargaining agreement. And it would be incumbent upon the city to sit down and negotiate that with them. That they have not done. So you can see that while on the one hand it may be too soon for them to take advantage of this retiree health benefit, certainly today the time is ripe for them to sit down and negotiate that if they want that security in the future. But I submit to the court one of the reasons the union may not have done that so far is they don't have support from their own members to vote for such a thing. Because remember, they have to make everybody happy. They come to negotiation with either one or two items or a list of items that their members want to bring to the table. Many times those items are not particularly well received by younger employees who retirement is years away. So they make a Hobson's choice, and that is their responsibility to do so. But we submit that unlike many of the cases that are cited in both briefs, the city here has never been unwilling to negotiate. In fact, in 93R 674, which is the resolution, subsection 6 specifically says that the city manager must negotiate with the union. That is something they never did. At the time, they expressly in writing waived their right to do that, and instead have gone forward over the years and haven't waived that, have continually waived their rights by inaction. I am not saying that at some point in time we can hold that waiver of years up and say, well, now we'll never negotiate with you. We recognize we may have to. But certainly for that time and all times going forward, they made a choice, and that choice was to not negotiate. Have I answered your question, both of your questions?
Thank you.
I don't know if I have any time left.
I'll give you a little bit more, how about
Okay.
30 seconds?
The
So you
only-
think of something else.
Okay, the only other points that I wanted to make is that PERC is, and as I said, this argument really does go to the active employees represented by Sergeant McHale. The retirees, as I also said, had time during their employment to make the choice to try to negotiate. They did not. Do they have other avenues? They may. They can come to a city commission meeting and bring it up. Many of those individuals live in the city. They have the ability to influence at the voting booth who is elected and if their particular subjects are addressed. As far as unfair labor practices, forcing people to negotiate, all of that comes within the purview of PERC. And remember, PERC was formulated in 1974. And it was formulated as a declared public policy of the state and the state constitution to promote harmonious and cooperative relationships between government and its employees, both collectively and individually, and to protect the public by assuring at all times the orderly and uninterrupted operations and functions of government. That is why there is a short statute of limitations for these things, because there needs to be labor peace. We do hope that in our brief that we have made all of these points, and we would hope that you would affirm the decision of the trial court judge. Thank you.
Thank you.
A few points I'd like to make and then answer any questions if the panel has any. One of the distinctions between the Auerbach case cited by the city and the facts in this case is that in this case, the rights for free lifetime medical and dental benefits for anybody hired after October 1 or prior to October 1, 1993 were vested, because the only condition was that for all active hires pre-October 1, 1993, they had those vested rights by virtue of the promises made by the city. If you stayed in office for 10 years, taking this all the way to 2003, everybody who satisfied that 10-year interval would be entitled to lifetime paid retirement free benefits. So every member of the class, of the two prospective classes, the active hires and the retirees who were pre-October 1, 1993 hires, had vested benefits according to the agreements made by the city. Now, the city now contends that the individuals, and we're not talking about the PBA, but we're talking about individuals, could have had the right to collective bargain. Number one, the city wanted PBA out of the case. They were dropped. We're talking about individual employees. They do not have a right to just inaugurate collective bargaining. They do not necessarily have a right to just seek PERC review. Moreover, it was the city, as alleged in the complaint and not rebutted by the city, it was the city that determined not to make these rights, these free lifetime benefits for pre-October 1993 hires, the subject of collective bargaining. We have an affidavit that was part of the record. It's alleged in the complaint that the city did not want to make that as part of collective bargaining, and now we hear, and I think it could have had some effect on the trial court, that these individuals should have treated this as something they should have collectively bargained. Only the PBA would have had standing to collectively bargain. And yet the city wanted them dropped, and they were dropped. And I think correctly so, because the city, the PBA itself, does not get retirement or benefits as an organization. It's the individual officers who did. The other point I'd like to make is that there are 3 instruments attached to the complaint which establish, I would submit, the promises that the city made. And if you look at those documents, to just cherry pick the resolution and say that doesn't cover everything thoroughly misconstrues what the standards are for interpreting whether or not contracts have been reached. You should look at all 3 instruments, and if you look at them, you'll see that in the resolution, section 4 says eligible employees hired on or after October 1, 1993 will be provided an opportunity upon retirement to voluntarily continue to participate in the city's medical dental benefits plan, provided that the cost to participate in the city's plan for retired employees and their eligible dependents is paid for by the retired employee. It doesn't say pre-October 1, 1993 hires will be doing that, and that is very suggestive, if not to me dispositive, that the city's promise was directed, that the promises the city made to pre-1993 hires that they would have lifetime paid benefits were indeed promises the city made. Exhibit B makes that completely clear. And if you look at Exhibit B, the language says, this discontinuation will not affect current employees or those hired before October 1, 1993. For those employees, the current policy of granting employee continuous paid medical dental plan coverage with 10 years of qualified service with the city and pension eligible will remain. So the city, in writing, is memorializing its verbal promises. And it's exactly what they did in 1993. They, who knows? We can speculate all day. Why didn't the city want to make that part of the collective bargaining agreement? I don't know why they didn't. But there's no refutation in this record that the city chose not to make those terms part of the collective bargaining agreement, and they chose to promise those benefits to pre-1993, October 1, 1993 hires. One other point I'd like to make is a lot of the arguments that were presented by the city at the hearing and here in oral argument by the city are speculation by counsel and not matters of fact or proof that was established in the record. A lot of it is just, we hear that the city would be willing to negotiate these. There's no evidence that the city was willing to do that. There's no evidence in the record that the city tried to do that. The only evidence of record based on the complaint and the affidavit is that the city did not wish to treat these rights for pre-1993 hires as part of the collective bargaining agreement. And now to say, well, maybe the city would negotiate that, really assumes a lot. I apologize, but I feel somewhat affronted because it's trying to suggest as if the city would, if we only had this brought up to us in a collective bargaining session, we would recognize our promises and our agreements. We would recognize them if you would just present them in that form. Well, I would submit that that's not a dependable position for anybody to take. It's what is being suggested, but there's no facts to consider that that would be done. And to have council now say, everybody's wrong except the city, it's not something that should be relied on either by the trial court or by this appellate court. Because the record shows it's the city that made these promises. The allegations in the complaint, I think, in my view, respectfully, the complaint adequately sets forth a cause of action for declaratory judgment and asking that these written instruments be construed, claiming that my clients are in doubt. It adequately sets forth a cause of action for injunctive relief, asking the court to enjoin the city from not providing free paid lifetime benefits, and that there's irreparable harm likelihood of success, the public interest. I believe all of the traditional elements for these counts were adequately set forth. And whether or not a count is joined for breach of contract, which I will concede perhaps ought to be added, and if it's remanded and reinstated, it probably will be, but I may need to file a separate action and consolidate it so I don't miss the statute of limitations. And if the city is here arguing that there's other parties...
I need to advise you that your time has expired.
If I may have just 2 sentences. If the city acknowledges there's other parties who are suing in court someplace, I'm not sure, I don't know exactly what the city was referring to, but that to me is pretty telling, that the city must understand that these are valid, judicially presented issues.
Okay,
And
thank
so
you.
it shouldn't...
We're done.
Thank you. Thank you, Your Honor.
Thank you.